Hey everybody, this is Ryan McClanahan with historythroughcards.com. Hope you're all doing very well today. This video I'm going to share with you the entire 1952 Bowman vs. Topps lawsuit. This is actually a different lawsuit from the one in 1953 with Judge Jerome Frank, the one that most people are familiar with. And that actually is an appeal. So this is the original case, and the judge in this case was Clarence G. Galston. He was born in 1876 and died in 1964. He went to NYU School of Law, where he received his law degree in 1899, and he was really well known as a specialist in patent law. And he was first appointed to the bench uh, in, let me see, I have that, April 29th, 1929 by Herbert Hoover, and he remained there basically until his death in 1964, and he gained senior service after January 1st, 1957, and he did write a book. I haven't read that book yet, but it's called Behind the Judicial Curtain, and he wrote it in 1959. If you are interested in that book, I don't really know a whole lot about Judge Galston other than the fact that he is really well known for being the judge to oversee parts of the Murder Inc. case from the 1940s, in which Louis Lepke and Mindy Weiss were sent to the electric chair in 1944. They were part of Murder Inc. So you guys can look up that case. It's really interesting if you're into organized crime. And Albert Anastasia is actually a part of Murder Inc. too. How he actually survived uh, that particular case is beyond me. But he ended up getting two in the hat basically in 1957. It's completely different from this, but I thought it was really interesting that Galston played a role in this. And so this is actually the first case that directly deals with Bowman versus Topps. And actually, Bowman did have another case in 1949 versus, I believe, Leaf. And so there are four major cases between 1949 and 1962 involving sports cards, and they all kind of like piggyback off each other, and the resulting Topps monopoly breakup in 1980. That one actually took about 4 years or so, between 1974 and 1980 or 81. And so this is one of the key cases. I think there's about four of these cases. I'm going to go through these. And another case that I might want to go through, let's see what happens, is the 1962 through 1965 Federal Trade Commission case with Topps. And that's actually 112 pages. This is not 112 pages. It's actually vastly shorter, but I wanted to get to this. And this is actually going to be a part one of a part two. So in my next video, I'm going to look at the 1953 Judge Jerome Frank case of Bowman versus Topps and their contracts. So there's actually going to be a lot of overlap between the 52 case and the 53, but there may be certain aspects of the 53 that you're not going to see in this case. I'm not entirely sure because I haven't read the entire case, Judge Jerome Frank's decision in that. So this is Clarence Galston's decision that I want to share with you, and there's a lot of hobby history here, and it is really interesting that a lot of the rarity of either the Bowman or Topps cards, or the non-issuance of some of the Topps cards here have directly to do with these two cases, and it tells us a lot about the manufacturing side of the cards themselves and why they're rare to begin with, or who got what. And so a lot of times we don't tend to think about the legality or the legal side of the hobby, which there certainly is one dating back to at least 1909, or if you really want to get technical about it, 1903. And I think they may actually bring some of the Robertson case into this too. But this is going to be really interesting, and it's going to maybe clear up a few things here regarding the rarity of some of these cards. And I think you're going to find it fascinating as I do. So here we go. Bowman Gum versus Topps Chewing Gum, U.S. District Court for the Eastern District of New York, March 31st, 1952. John W. Thompson, New York City for plaintiff. Daniel L. Morris, Robert D. Spile, New York City. Shapiro, Rosenfeld, and Stahlberg, Philadelphia, PA, of counsel. George E. Middleton, New York City, for defendant. Hubert Moore, Jr., New York City, of counsel. Galveston, District Judge. In a single cause of action, the plaintiff alleges trademark infringement, unfair competition, and impairment of contract rights. The parties are citizens of different states, the plaintiff being a Pennsylvania corporation, Bowman, and the defendant a New York corporation, Topps. The plaintiff and its predecessors have been and are engaged in the business of selling chewing gum throughout the United States. The chewing gum product is known in the trade as card bubble gum. Plaintiff claims to be the first to have employed picture cards featuring leading baseball players in connection with the sale of its product, Play Ball. Was its earlier trademark used in the years 1939 to 1942 inclusive. In 1949, it adopted the trademark Baseball. Bubble chewing gum was sold in packages which included serial numbered cards forming sets bearing the names, pictures, and biographical data of various well-known baseball players. Though the complaint alleges that the trademark Baseball has been and is now widely and generally known to the public as identifying the origin of the plaintiff's said product, the proof does not establish that connection. Plaintiff entered into contracts with 340 Major League Baseball players, pursuant to which it acquired the exclusive right from such players for limited periods to exhibit, display, print, and publish the name and/or signatures and/or facsimile thereof and/or photograph and/or descriptive biographical sketch of each of the said players in the advertising, promotion, and sale of chewing gum. In these contracts, the players agreed that they would not grant to any other manufacturer of chewing gum the rights granted to plaintiff. The defendant is charged with an invasion of the rights which the plaintiff claims to have established in connection with the distribution of its product under the trademarks referred to and with the accompanying photographs of baseball players of the major leagues. It is claimed that the defendant placed on the market a product consisting of a flat, rectangular piece of sweet-tasting substance, simulating a flat piece of chewing gum, and sold packages under the designation Baseball Trading Card Candy. Each package of candy of the defendant includes a card which bears on one side markings of a baseball, the name, picture, and biographical data of a player currently enrolled in one of the major league teams. The card forms one of a set of 52 photographs. Plaintiff claims to be the owner of the exclusive rights in 1951 players' contracts, with some few exceptions, and claims that the defendant's packages designated official trading cards are sold and offered for sale with knowledge of plaintiff's exclusive rights and without the consent of the major league clubs by which the pictured players are employed and whose 1951 contracts with the plaintiff precluded defendant from lawfully obtaining such consent, and plaintiff claims that with knowledge of the plaintiff's player contracts, some of which contain options, defendant has attempted to enter into agreements with the Major League Baseball players who are under contract or option with the plaintiff, all of which has the effect, so it is alleged, of impairing the value of plaintiff's rights under its contracts. In consequence, the plaintiff seeks an injunction to restrain the defendant from using the word baseball from its publishing or using in connection with its sales any confection bearing the name and any likeness or biographical data of any league baseball player in any baseball season during which plaintiff has the exclusive right to use any such player's name, likeness, or biographical data, and from selling any product having the appearance of gum with the word baseball in connection therewith. The answer to the amended complaint puts in issue the charge that defendant's candy simulates the chewing gum of the plaintiff, admits that it sells packages of candy under the designation baseball trading card candy, but denies that in doing so it invalidates any of plaintiff's rights, admits to the sale of official trading cards, but denies that such sale violates plaintiff's rights, admits that it has obtained from an organization known as Players Enterprises, Inc., the right to use the names, pictures, and biographical data shown on its cards, resulting from the contracts which Players Enterprises have with the players, denies any confusion with plaintiff's products, and affirmatively charges that it has been common practice for 50 years or more, and still is, that it has been customary to define such products as picture card gum, or candy or trading card gum or candy, as the case may be. Also, that the picture cards or trading cards included a variety of pictures, including soldiers, sailors, battleships, flags, animals, Indians, prize fighters, wild men, Wild West scenes, football players, baseball players, etc. The answer also raises the issue as to the validity of plaintiff's use of the term baseball, charging that when applied to the goods of the plaintiff is devoid of trademark significance and is incapable of acquiring trademark significance, as asserts that the term baseball is used fairly and in good faith by the defendant only to describe the users, the goods of defendant. Defendant claims that no one could possibly purchase defendant's picture card candy in the belief that he was getting plaintiff's baseball picture card gum. As to the charge that defendant's conduct has impaired the value of plaintiff's alleged contracts, the defendant alleges that such claim fails to state a cause of action upon which relief can be granted, since the contracts which plaintiff made with the players at most constitute a waiver of the players' rights of privacy and convey no rights upon the plaintiffs to sue a third party. Defendant's rights to use the names and biographical sketches of baseball players concerning which the plaintiff complains are derived from contracts which Players Enterprises, Inc. or Russell Publishing Company made with those ball players. Defendant has no direct dealings with the players. The defendant alleges, too, that the plaintiff knowingly induced many of the ball players to breach their contracts with the Russell Publishing Company and with Players Enterprises. It is also claimed that the players who are under contract to the plaintiff were misled by the misrepresentations of plaintiff into believing that the negative content, like the release itself, was limited to chewing gum, and that the players signed in that mistaken belief. The answer also sets up a counterclaim in the form of declaratory judgment seeking the cancellation of plaintiff's registered trademark under Section 119, Title 15, U.S. blah blah blah. It is claimed that the registration was granted contrary to the provisions of the Trademark Act of 1946, particularly Section 2, thereof 15 USA, blah, blah, blah. Again, summarized that it may be said through the plaintiff in the sale of its bubble gum under some designation bearing the name baseball and its packages containing photographs of baseball players was the field before the defendant. It was not the first in the field to offer articles of merchandise for sale with picture cards of one of a kind or another, nor was it the first to use baseball in connection therewith. For example, the system of doing business by enclosing pictures of baseball players with gum or candy was old before plaintiff sold baseball picture cards with its gum. The proof shows that the Gowdy Gum Company of Boston followed that practice from 1933 to 1945. Similarly, the defendant did so in 1948, as did the Leaf Gum Company of Chicago in 1948 and 1949. A like method of doing business was followed by the Philadelphia Chewing Gum Company in 1949. But let us first consider the charge of trademark infringement. The infringement complained of is the designation by the defendant of its products under the names which include the term baseball. Plaintiff does not claim that its certificate of trademark registration number 546225, containing the word baseball repeated and with pictures of baseball players, presumably of a picture of a pitcher and a catcher, was infringed by the defendant. It relies rather on what it claims is its common law trademark, the term baseball, in connection with the sale of its bubble or chewing gum. But the term baseball is not subject to monopolistic appropriation by the plaintiff. The term is generic and descriptive, nor is there any proof that as used by the plaintiff it acquired secondary significance as indicating the source or origin of the gum sold. Nor is there any secondary significance arising from the designation of the product in connection with the name of any famous player. The case might be different if the plaintiffs were selling a product under the designation of some one name. Such use might readily build up goodwill, and an invasion on the part of not one privileged to use the name would be subject to restraint. In the circumstances of this case, though, we have no such situation. On the contrary, the facts and applicable law fall readily within such authorities as Kellogg Company versus National Biscuit Company, or Nabisco, in which it was held that shredded wheat was a generic term not subject to exclusive appropriation by the original maker of the product. The court said, quote, but to establish a trade name in term shredded wheat, the plaintiffs must show more than a subordinate meaning which applies to it. It must show that the primary significance of the term in the minds of the consuming public is not the product, but the producer, unquote. Thus, it must be concluded under the authorities of the term baseball is available to anyone to be used freely if honestly employed. Secondly, as to the claim of unfair competition, there is no suggestion in the record that the defendant was palming off its goods as the goods of the plaintiff. The dress and packaging of defendant's baseball trading card candy is outstandingly different from the dress and packaging of plaintiff's baseball picture card bubble gum. Also, though the plaintiff gives the biographical data of the baseball player on the reverse side, that is not done by the defendant. Another item of difference exists between the posturing of the ball players on the plaintiff's cards and the absence thereof on the defendant's cards. There is no proof of any deception that there was practiced of any of plaintiff's customers, and likewise the record is barren of any proof that there is likely to be any confusion among those who purchased the products of either, or that the defendant has offered them as the products of the plaintiff, directly or through devious means. The plaintiff, of course, acquired no monopoly right in its system of distributing its pictures with its gum. This leaves for consideration the claim of impairment of plaintiff's contractual rights. Beginning in the playing season of 1948 and continuing through it, these contracts were procured for the plaintiff by an organization known as Art Flynn Associates. By the terms of these contracts, the player gave plaintiff permission to use his name, photograph, and biographical sketch in the advertising, promotion, and sale of its chewing gum, and agreed not to give any other manufacturer of chewing gum the same permission. In the 1950 contracts, plaintiff was additionally given an option to renew for 1 year on the same terms stated in the contracts that ran therefor, but for 1 year. Plaintiff paid as consideration the sum of $100 each year until the 1951 contracts were executed. They provided for payment to the player of a wristwatch. Significantly, the 1951 contract included for the first time the words "or confections." The inference seems irresistible that the inclusion of that right was predicated on a knowledge that the defendant was using baseball photographs to aid the sale of its candy. The first of such, or confections contracts, was signed on August 8, 1950. The current form of contract which the plaintiff has negotiated and is negotiating covers the period from January 1st, 1952 to December 31st, 1956, and includes the privilege of use of photographs not only with chewing gum but also with the sale of confections or confectionery. The history of the defendant's use of baseball players' photographs may be traced to the rights which it acquired from the Russell Publishing Company and Players Enterprises, Inc. The evidence shows that the former company was active in the spring of 1950 and entered into contracts with 248 active Major League Baseball players. It acquired for itself or its assignees or licensees the exclusive permission to use the names of the players, pictures, and biographical data in flip books, cards, and labels in connection with the sale of any product except those which might be specifically named therein. Those contracts covered the period from October 2nd, 1950 to October 2nd, 1951, with an option for renewal for 1 year on these same terms. At or about the same time as it to say in July 1950 and through August and September of that year, another corporation known as Players Enterprises, Inc. entered into contracts with a number of active Major League Baseball players by the terms of which that company obtained the sole right for a period of 3 years to license the use of the names of the players and their likenesses in connection with the manufacture and sale of merchandise. Also, with knowledge that players had signed other contracts of a like nature, the player's contract provided that any prior contracts for the use of the player's name or likenesses should not be affected, but the player agreed that he would not renew any such existing contract and that all future agreements for the use of his name or likeness, except for testimonials would be made through Players Enterprises, Inc. The defendant in December 1950 acquired from Players Enterprises an exclusive license to use the Players' rights which Players Enterprises had acquired in connection with the sale of candy for 1951 and of candy and chewing gum for 1952. It was pursuant to this license that the defendant brought out an issue of 1951 baseball picture cards with its candy in April 1951. The scope of its distribution was also enlarged in April 1951 when the Russell Publishing Company and Players Enterprises merged, and as a result of the players under contract to Russell were also available to the defendant. Acting under such license from Players, the defendant distributed a second series of 1951 baseball picture cards with its candy in June 1951. Parenthetically, it may be observed that the makeup of the 16 major league teams, 8 in the National League and 8 in the American League, shifts from year to year. Each club makes changes not only between seasons but also during the playing season. At times, old players pass out of the league and their places are filled by the younger men from the minor leagues or elsewhere. These continuing changes in the makeup of the baseball teams have made it necessary for all those who wish to obtain releases from players to negotiate with those who are not already under contract. So, beginning in May 1951, Players Enterprises entered into new contracts with 283 active Major League Baseball players, by which the corporation acquired rights similar to those heretofore described. These contracts in the main covered the 1952 playing season and contained options for renewal. As before, the players agreed that during the term of such agreement he would not grant to anyone else the rights released to Players Enterprises and would not renew any contract with others except such as might be listed. The claim of the defendant is not only that it did not invade contractual rights of the plaintiff, but that it sought to be appraised as it took licenses from Players Enterprises. Whether the player had committed himself under any other contract, there is no evidence that the plaintiff made any such inquiry prior to signing up for the players in which it holds under contract. It may well be that the plaintiff believed that the first in the field and therefore though it unnecessary to pursue any such investigation. Another element that may be noted is that the defendant manufactures not only candy and chewing gum, but also toys, and has sold, independent of any commodity, sets of baseball trading cards. A consideration of the law of the case in respect to the impairment of contracts as presented by the parties leads to the conclusion that the New York law must prevail. The signatures of the baseball players to most of these contracts were obtained by Miss Joan Crosby and Mr. Jack Tanzer as agents of the plaintiff. The contracts themselves do not state where they were executed. However, in Miss Crosby's deposition, she states that most of the contracts were signed at the baseball parks over which she had jurisdiction. She testified that these ballparks were the Yankee Stadium, Ebbets Field, and the Polo Grounds, all in New York City. Also, for the 1952 to 1956 contracts, Griffith Stadium in Washington, D.C., and Shibe Park in Philadelphia were included. The deposition of Jack Tanzer, also in evidence, does not disclose his territory. In addition, both depositions indicate that some of the contracts were received from the players with their signatures through the mail. No effort was made at the trial to show where the individual contracts had actually been executed. Jurisdiction here is based upon diversity of citizenship. The plaintiff alleges that the interference complained of occurred within New York and within the territorial jurisdictions of this court. In support of their contentions, both parties have based their arguments upon what they deem to be the law of New York, in view of the failure to distinguish the contracts individually as to the place of execution, indicating thereby a desire to treat the rights granted thereunder as being substantially alike, and the fact that the evidence indicates that most of the contracts were executed in New York. It may be assumed that the parties here take the position that the applicable state law that is that of New York. The plaintiff's case, narrowed down as I have indicated, thus poses the problem as that the nature and extent of the rights that the acquired under the contracts that it has with the ball players. To put it otherwise, did the plaintiff, as a result of the contracts, acquire the right to prevent others from using the photographs of these players, or, as the defendant contends, did the plaintiff get merely releases or waivers, i.e., the right to use the rights described in the player contracts? It is clear that in none of the contracts with the ball players with either plaintiff or defendant was there a motion of any right on the part of the plaintiff or defendant to pursue others, persons who, without players' contracts, used photographs and data in connection with the sale or of commercial products. There is not much authority to guide us to the solution of this problem. In Robertson versus Rochester Folding Box Company, it was held that there was no common law right to prevent the unauthorized publication and disruption of and distribution of a person's portrait or photograph. And that's actually 1903. I'll go into that, and I've gone into that in other videos as well. The court declared that the act complained of was an invasion of the right of privacy, which it held to be an interest in an inviolate personality rather than the private property. Subsequent to the Robertson decision, legislation was enacted granting an action for injunction and for damages to any person whose name or picture is used for advertising purposes or for the purpose of trade, without first obtaining the written consent of the person. In establishing the right to an injunction or for damages for the unauthorized use of a person's name, portrait, or picture, Section 51 of the Civil Rights Law, as construed by the state court decisions, did not create property interest. In Gaudier v. Pro Football Inc., the court construed that the scope of the statute in the following language: the statutory creation in this state of a limited right of privacy was intended for the protection of the personality of an individual against unlawful invasion. See Robertson v. Rochester Folding Box Company. It provided primarily a recovery for injury to the person, not to his property or business. True, where an individual's right of privacy has been invaded, there are certain other elements which may be taken into consideration in assessing the damages. Thus, where a cause of action under the Civil Rights Statute has been established, damages may include recovery for a so-called property interest inherent and inextricably interwoven in the individual's personality. See Redmond versus Columbia Pictures Corp. And I haven't looked into that case, so I don't know anything about that. But it is the injury to the person, not to the property, which establishes the cause of action. That is the focal point of the statute. There is no right of privacy under our statute applicable to a business. It is the individual, not his business, which is protected against unlawful intrusion. Section 51 of the Civil Rights Law was not enacted to fill gaps in our copyright statute, which was 1909 actually, or to supplement causes of action based on contracts expressed or implied, or to extend the law relating to unfair competition or to the appropriation of another's business or enterprise. Pecos Co. Inc. vs. Leslie 52, New York Law Journal, 1864. Oh, we're going back to that? February 13th, 1915. Okay, fine. It is very pertinent, for the very question was considered by Justice Greenbaum. It appeared that the plaintiff, a publisher of posterettes, art stamps, and advertising stamps, secured from certain motion picture actresses the inclusive right to use their pictures on posterettes, art stamps, advertising stamps, and seals for a period of 5 years. The defendant thereafter also published, without the permission of the actresses, posterettes or portrait stamps of the same actresses. Just as the pending case, it appeared that these actresses had not authorized the plaintiffs to bring any action for injunction or damages against said defendants, or either of them. Indeed, the actresses filed affidavits which contained a request that no injunction be issued in the action. No copyright question was involved, and the judge wrote, "The complaint is clearly predicated upon the theory that the defendants are liable to plaintiff under sections 50 and 51 of the Civil Rights Law, entitled Rights to Privacy. The history of the legislation resulting in that act is found in Rhodes v. Sperry and Hutchins Co. It doesn't give me a date here in which that happened, but that's okay. Which convincingly established that it was promoted by the suggestions of the court in Robertson v. Rochester Folding Box Company. A study of the learned prevailing opinion in the Rochester case clearly reveals that the law of privacy is what the phrase indicates, not one designed to protect the rights of private property, but of an inviolate personality based upon the regard of the law for the feelings and sentiments of the individual. The rights and remedies of the persons aggrieved are purely personal and not assignable. Rights for outraged feelings are no more assignable than would be a claim arising from libelous utterance. The alleged agreements made between the actresses in question and the plaintiff, under which the plaintiff was given the exclusive rights to publish the portraits, may have conferred rights which the plaintiff might have protected by copyright, but none in favor of the plaintiff against the defendants under the civil rights law of privacy, judgment for the defendants without costs. This opinion is of such importance that the plaintiff has supplied the court with photostat copies of the pleadings, briefings, findings, conclusions, and judgment therein. But an examination of these papers does not change the conclusion forced by the foregoing consideration of the facts and law. A federal case which follows the New York law, though the contract under consideration was not negotiated in New York, is of considerable interest, for the facts are very similar to those in this case. See Hanna Manufacturing Company versus Hillerick and Bradbury Company. Doesn't give me a date on that one either, but I can find that out. It appeared that the certain baseball players had given to Hillerick and Bradbury Company, manufacturers of baseball bats, the exclusive right to use their names and photographs in connection with the sale of baseball bats, and had consented to the registration of their names as trademarks. The defendant, Hanna Manufacturing Company, was selling baseball bats under the designation Ruth or Gehrig bats, which indicated special bats known to the trade under those names. Judge Silby, writing for the Court of Appeals, said, "From this incomplete review, it is evident that a famous batsman, aside from questions of trademark and unfair competition or libel, might have difficulty in keeping his name and likeness from respectful use by others. But if they be his property in sense, They are not vendible in gross so as to pass from purchaser to purchaser unconnected with any trade or business. Fame is not merchandise. It would help neither sportsmanship nor business to uphold the sale of a famous name to the highest bidder as property. Moreover, appellee is not by its contracts the assignee as of property of the name and likeness of these players. The usual form of the contract grants the sole and exclusive right for 20 years of the use of my name, autograph, portrait, photograph, initials, or nickname for trademark or advertising purposes in connection with the manufacture or sale of baseball bats. The signer does not divest himself of his name and likeness, but gives a permission or license to use them for a stated purpose and for a limited time. Since the players were not makers or sellers of bats and sold no business together with its marks and good will to appellee, the contracts, in our opinion, in and themselves operate only to prevent the signers from objecting to appellee's use of their names and likeness. The right or wrong as against appellee of their use by others rests on the law of trademark and unfair competition, or unfair trade, and depends not so much on appellee's contracts as on the actual use and trade by appellee of the names and likenesses. It is the trade rather than the names and likenesses which the law will protect as property. Cases cited by the plaintiff do not change this view. Fisher v. Star Company holds that a cartoonist who originates the name of fictitious grotesque characters acquires a particular value in interesting the public through newspaper publications and may enjoin other publishers from using the names imitating his drawings for purpose of leading the public to believe that their work is his. This is not a case in which the third party under contract to the cartoonist pursued the invader. Nor does Wood vs. Lucy Lady Duff Gordon help the plaintiff, for the facts were quite different. The same is true of Rogers vs. Republic Productions, Inc. And the case of Uproar Company versus National Broadcasting Company. Again, this is all case law that you guys really don't need to know. And quite frankly, I don't know anybody else except maybe lawyers who like to study history of law or other cases need to really get into and follow. Most of the stuff is just dry as the Sahara Desert anyway, but they use it here to kind of justify their reason, if you will. In Wood vs. Duff Gordon, the plaintiff had acquired the exclusive right to place Lady Duff Gordon's endorsement on the designs of others and to place her own designs on sale. Lady Duff Gordon placed her endorsement on fabrics, dresses, and millinery without plaintiff's knowledge and withheld the profits for which she was sued. The question whether there was an enforceable contract was presented, and the Court of Appeals held that there was. Rogers vs. Republic Productions involved property in commercial advertising. In Rainier vs. North American, the facts are quite different from those presented in this case. Then why bring it up? This really ticks me off. Anyway, there the plaintiff had fraudulently obtained passage on the Graf Zeppelin and had agreed that he would not broadcast news of the trip, for the owners of the ship had given the exclusive to recover from another the price agreed to be paid for his wrongful act. The contracts between the ball players and the plaintiff here did not call for the performance of any services on the player's part, nor did they require the players to endorse the plaintiff's product. It is also significant that there is absent any substantial evidence proving that though the plaintiff's efforts, time, and money, the baseball players' picture cards have acquired a special significance which would associate them in the minds of the buying public with the plaintiff or its product. Proof of such circumstances might well bring the case within the principle which formed the basis for granting protection to the defendant against the unauthorized use by the plaintiff of the name Graham in Uproar Company versus National Broadcasting Company. The district court had the following to say in its opinion on this point. The defendant, National Broadcasting Company, through its artist service, has created a commercial value in the name Graham McNamee, and he has been identified with the National Broadcasting Company for several years and has never been identified with any other broadcasting company. The use of the word Graham would, in the public mind, mean Graham McNamee, especially if used in connection with the radio program sponsored by the Texas company. The name acquired through the efforts of McNamee and the National Broadcasting Company a very substantial value, especially valuable for advertising purposes, and this definite commercial value exists apart from the services as radio announcer. Rights of a pecuniary nature have been created which partake of the elements of property rights and which will receive the protection of equity. International News Service versus Associated Press. Now, I do know that's from 1945 because I did actually read that one. These rights may properly be the subject matter of a transfer from McNamee to the broadcasting company. Implicit in the decision in the Uproar case is the suggestion that the use of the name Graham by the plaintiff amounted to an appropriation of goodwill created by the defendant broadcasting company at great expense, and that such appropriation constituted unfair competition. Thus, it may be said that before the enactment of sections 50 and 51 of the Civil Rights Law, I presume that's from 1903, there was in New York no legal basis for protection against the unauthorized use of a person's name or portrait in the absence of a violation of the law dealing with libel and slander, or some independent property or contract right. With the enactment of sections 50 and 51, the legislature granted certain limited protection against unauthorized publication of a person's name or picture, that is, where the intended use is for advertising purposes or for the purposes of trade. The protection thus granted the statute is a right of privacy, construed by the courts of the state as being a purely personal right and non-assignable. The plaintiff denies that its claim is based upon a violation of the right of privacy statute. It insists that by virtue of its contracts with the ball players, it obtained rights in the nature of a property interest which is entitled to protection. However, the cases plaintiff cites all involve property or contract rights independent of the right obtained through the contract to the use of names and pictures for the purposes of trade for advertising purposes. I conclude that the plaintiff has failed to sustain the cause of action alleged. By the same token, the defendant's rights in and to its contracts were, of course, no greater in matter of law than those acquired by the plaintiff. That is to say, that the defendant, like the plaintiff, failed to acquire from the players the right to pursue third parties. As to the other branch of defendant's counterclaim seeking cancellation of plaintiff's registered trademark, that too must fail, because at least on the face of it, the trademark covers registrable matter, The complaint and the defendant's counterclaim will be dismissed, settle a decree on notice. Appropriate findings of fact and conclusions of law will be filed with this opinion. Ah, man. So there's a reason why no other YouTuber is going to read that case verbatim. And a lot of these cases, you're not going to have anyone read either because, quite frankly, a lot of that stuff is just dry as the Sahara. And in most cases, you need to have a legal background and a knowledge of, I guess, back cases, if you will. Uh, I don't particularly care to do that kind of stuff. If it's baseball related and baseball or sports card related, I don't mind doing that. I'm taking one for the team. I'm doing this for you guys. Uh, and it's great conversation on a first date. Let's just be honest with that. No, I'm just joking. Don't ever say anything that I just mentioned in a court case on a first date because it will be your last. Um, Take it from me. This is really interesting because for various reasons. There wasn't any cases prior to Roberson versus the Rochester Folding Box Company that dealt with the right of privacy. That was the first one. That's why it's so important even today. And Mrs. Robertson, she initially won her case, but then she lost it on appeal. And the same thing kind of applies here as well. Roberson is again, it's a very, very important case, and a lot of other cases, such as this one, it hinged a little bit on Roberson. And from that Roberson case, you get the personal privacy statute of 1903, even though that case, it was, I believe, 1900 or so. So it took like 3 years for New York to kind of like say, hey, wait a minute, like these people actually have the right of privacy, in which that there was a sports writer from, I believe, New York, who said to Neil Ball that we're getting together a a card set which would be the T206. And but in order to do this, we need to have your permission. So there was actually a non-baseball player who disagreed with this. He didn't apparently agree to have his likeness, and that was this guy Porter, and he was a gold medalist in the, I believe, 1908 Olympics, and he lost his case, and I've actually written a little bit about that because that one's kind of important too. So, what's the difference between Harry Potter, the Olympian, and Honus Wagner? Honus Wagner, being a very famous baseball player at the time, saying that he didn't want his likeness in a tobacco set, and Harry Potter apparently said that he didn't want his likeness in a tobacco set either. Although Harry Potter lost his case, and Honus Wagner forced American Lithograph Company to pull his card. I don't know what the difference is here. I can't tell. Porter lost his case, obviously, and Wagner just threatened the company. Apparently, we don't have any legal background for that. I don't believe there are any actual documented evidence for Wagner to have actually done that. Anyway, I'm looking at the legal evidence that we have, not what is said in a publication or with John D. Wagner, who met Honus Wagner in 1942 and relayed the story to the hobby. So, a good story is fine, but it should be backed up by actual fact. And in this case, we have the documented legal evidence of Harry Potter's case and not Honus Wagner's. So again, that's a whole different story, I guess, but it's still connected to the 1952 and 1953 Bowman versus Topps scenario here, and I find that very interesting. The other thing that they mentioned too is the Copyright Act of 1909, and without either the Robertson case or the Copyright Act of 1909, which was instituted in, I believe, July of that year, you wouldn't have the T206. So it's very, both of those are very important laws. This is also very interesting too that they mentioned Joan Crosby. She was assigned to sign the ball players for Bowman, and because she was a woman, she couldn't go into the clubhouses to get these guys' signatures, and so she had to wait outside. Meanwhile, you have Cy Berger of Tops, who could just stroll right on in to the clubhouses and get these guys' signatures. And every team at the time had a representative. So, for example, the Washington Senators, it was Eddie Yost. And so all the players who wanted to basically partake in, say, a 1950 or 51 Bowman set, they would have Eddie Yost help them out or get together, and Eddie Yost would have these guys sign contracts with Bowman. And presumably, this also happened with, say, the Pittsburgh Pirates or the Philadelphia Phillies way back in, say, 1909, 1910, around there. Because if you notice, some of the key players for the Pirates and the Philadelphia Phillies are not on the T206. So it's thought that you may have had like a player rep, say Eddie Plank. So um, his cards actually may mirror uh, Honus Wagner in some sorts. But what I think here with in regards to Plank, and I know we're going off topic here, but with Plank, he actually had a friendship with the owner of the American Caramel Company, a guy named Daniel Lafine. And Lafine actually helped him out quite a bit getting into college and all that other good stuff. So uh, Lafine, um, he probably got to Plank first and had Plank sign a contract with the American Caramel Company instead of the American Tobacco Company. That could be a very good reason why we see so few T206 planks. And that also may be the reason why we don't see a lot of uh, Pittsburgh Pirates and Philadelphia Phillies players in the T206. So, getting back to Bowman here and Tops, obviously, I think they're talking about the 1951 Tops sets. They're basically game cards, if you will, and they're not talking about the 1952 Top set yet. That's my perception of it. I could be wrong, but we're going to have to see in part two of this, which is going to include the 1953 case with Judge Jerome Frank. And he's actually a really interesting judge himself. And a lot of this also was in the press at the time, too, up until like 1965 or so. And in part two of this, you're going to see a lot more ball players being mentioned and their contracts and specific dates. So I think that's why one of the reasons you don't hear too much about the 1952 case is because you don't really have Judge Clarence Galston here talking about the ball players, which I know a lot of the fans and collectors like hearing the names of these guys. So that's going to be in part two of this. So this is really interesting. Even though if you're not into the law, it kind of helps you to understand why some of these cards are rare to begin with, or why you have certain players who may have cards and were pulled from production. So this doesn't appear to affect the Bowman football sets. The thing that affects those sets, particularly 1952, is the dimensions of the sheets. And basically, those sheets had to be cut in a certain way because of technology. It doesn't really appear that contracts for Bowman football were ever touched. or even looked at. I don't think that has anything to do with these cases. Just seem to be surrounding baseball for now. Case law to me is really boring stuff, but unfortunately, or maybe fortunately, uh, sometimes it needs to be included in a another case in order for it to make sense or have precedence. Sometimes you're not going to have precedence in a case because there is no case law to follow. And just like Robertson, she lost her case because the judges and the courts didn't understand uh, the right of privacy at the time. It was just a very brand new subject that the courts didn't have to face, and now all of a sudden they did. So sometimes technology comes in, and the people who have to define what the technology is and how it either hurts or helps either the plaintiff or whoever it is in the case, uh, they have to find out whether or not this stuff will hurt or help society as well, and that can be very difficult. And sometimes, even if you have a very thoughtful judge and a well-read judge and jury doesn't mean that they will always understand the laws or the concepts behind what is being brought to court. So that's something that we all need to kind of keep in mind here too. And then you need standing as well. And sometimes if you don't have standing, they're not going to hear the case. Anyway, guys, thank you so much again for stopping by. I greatly appreciate it. Uh, I would love to hear what you guys have to say about this. Give me a like and subscribe, if you will, for more very interesting content. And I will talk to you later. Have a good one. Bye.